Okay, our next chapter is chapter 6 on the Judicial Branch. I'm going to start with three things that I think are kind of guaranteed points or topics on the exam, and that is Article 3, the part of the Constitution itself, the Judicial Branch is explained, Federalist Paper 78, and Marbury versus Madison as a required court case. So let's start with Article 3. Article 3, we'll look at this in class, but focuses on the federal judiciary. A couple things to understand. It is a very brief article, and the first thing it explains is the federal court system will consist of a supreme and inferior courts. No more definition than that. There wasn't an explanation on how many inferior courts there would be. There was no explanation, and there are no details on requirements to be a member of the federal judiciary, just that there shall be a supreme and inferior courts, and the members appointed to those courts will have lifetime appointments during periods of good behavior. So basically it's a lifetime appointment. Supreme Court, the federal courts themselves have jurisdiction over a few different kinds of issues. They have jurisdiction over any constitutional issue. They also have jurisdiction over treaties and jurisdictions between states and citizens of different states that have conflicts. And of course they have jurisdiction over federal criminal issues. We'll get into that a little bit later. When we talk about jurisdiction in the court, it's first outlined in Article 3 and explained that the United States Supreme Court has both original and appellate jurisdiction. You need to recognize the difference between those two phrases. Original jurisdiction means that they have the power to hear some cases first. Some cases go directly to the United States Supreme Court. For example, if it's a case against a foreign diplomat, that case would go directly to the U.S. Supreme Court. Most cases that go to the Supreme Court get there through appellate jurisdiction. In other words, the court has the power to hear cases upon appeal from lower courts. The next item is a required Supreme Court case, and that's Marbury versus Madison from the early 1800s. This is still John Marshall as the Supreme Court Chief Justice. 1803, I believe, is when this court case was from. This case dealt with the appointment of what were referred to as midnight judges by President Adams on his way out of office. When President Adams was leaving, he was appointing people to the federal judiciary, but their appointments did not get officially delivered all the way to them, and so they didn't take the bench. One of the judges was suing to have his appointment delivered. So this case was about, as far as a technical issue, can the courts force a delivery of this appointment? And does the individual who's suing actually have the ability to sue for that position? This was a difficult case for the Supreme Court because they didn't want to set up a system in which they felt like they were actually weaker than the other branches. And so what Marshall and the court ruled was that, yes, this individual had the right to sue. However, they declared the law that gave them the power to force the delivery of this appointment as unconstitutional. That's important because Marbury versus Madison established the precedent that the Supreme Court, the federal courts, have the power of judicial review. They have the authority to determine whether a law or an action is constitutional or not. So that came from Marbury v. Madison. The third kind of, I think, almost guaranteed part of the exam is the foundational document, Fed Paper 78. Federalist 78 was written by Hamilton again, like Fed 70. And in this, he talks about the need to give judges lifetime appointments, which was controversial with some anti-Feds. And his argument was that lifetime appointments help both protect the law and the principles of the Constitution. And his logic was, you're creating a branch that is impartial. They are not dependent upon the legislative or the judicial branches of government to keep in their favor once they're given their position on the courts. Their only job is to interpret the Constitution and to examine the law and to make sure it fits. All right. As a result of that, what you're getting is, in the words of Hamilton, these weren't used in the Constitution, but Hamilton talked about the need for the courts to have this power of judicial review that eventually Marshall awarded to us, or cemented in the ruling of Marbury versus Madison that we just talked about. If you want to become a judge on the federal courts, whether it's lower level federal courts or the highest court in the land, the United States Supreme Court, you go through the same process. The president has the power to choose members of the federal judiciary. Those individuals are then approved by the United States Senate by a majority vote. what we've seen over the last few decades, really probably since the 1980s, is that this process has become more and more contentious, more and more partisan, as the political parties in the Senate are fighting to make sure that the justices that get on there do not direct the court in a manner that is unworthy of the office itself or the positions themselves. One of the places where there is not as much partisanship is at the appointments of judges to the federal district courts, which we'll get into in a second here. The district courts are the federal court, the lowest court in the federal court system. Every state has at least one federal district court. And if you want to get appointed to a federal district court job on the bench there, you must go through the process that's known as senatorial courtesy. This process isn't written anywhere in the Constitution, but George Washington started this habit in which the president will ask a member of the United States Senate from the party that he's a member of, who would you like me to appoint to the bench? And so he will extend the courtesy to the senator to the state the individual will sit on the bench. That individual will give them a list or approve it, a suggestion by the president, and then the Senate will approve that individual. Now, if the president doesn't go through this process of senatorial courtesy, it's almost a certainty that the Senate will reject the nomination because all the members want this courtesy to be extended to them if they have the opportunity. We just mentioned the district court. You need to understand the structure of the federal court system. And so there's really two different types of federal courts or umbrellas of federal courts. The first umbrella, if you will, is what are referred to as constitutional courts. These are the courts that come out of the words I mentioned earlier from Article 1, that there shall be a supreme and inferior courts. The constitutional courts that are based on that article itself, sometimes they're also referred to as Article 3 courts, are the United States Supreme Court, the United States Courts of Appeals, and the United States District Courts. District Court is a court of original jurisdiction in the federal system. If you lose there, you have the right to appeal to one of the 12 circuits or one of the 12 U.S. Courts of Appeals. From there, you could then appeal to the United States Supreme Court, of which, of course, there's only one United States Supreme Court. At the U.S. Supreme Court, we have 9 justices. All right, again, there are no requirements in the United States Constitution. There are also no clarity on how many justices were supposed to sit on the bench. So the number of justices that have sat on the bench over the years have actually changed from one time period to another. We have the district courts and the appellate courts thanks to a law known as the Judiciary Act of 1789. It's a really important law that you understand, or connect the Judiciary Act of 1789 with these constitutional courts. That law helped create the structure that would develop the district and the appellate court system that we currently live under. The other type of courts that we have are referred to as Article 1 courts, or also known as legislative courts. Legislative courts are specialty courts. They're courts that were created by Congress sometime after the Judiciary Act of 1789. And what these courts do in the federal system is they handle issues of fine specific interests. For example, there's a United States Claims Court, a United States Tax Court, a United States Court of Military Appeals. So if you ever see a name of a court with the U.S. in front of it, and there's an area of specialization like tax or claims or military, you know that's a legislative court. What makes those things unique is if you're a federal judge on those courts, you do not get a lifetime appointment, because those courts were not created by Article 3. They were created by Congress at some later date, and Congress has put terms on those positions. All of the federal courts can hear either criminal, all might be a stretch, but the federal courts themselves overall can hear both criminal and civil cases. A criminal case is where somebody is being charged with violating some statute, either against a state or the federal government. All right. A criminal case, an individual could end up in jail potentially for a conviction. They also hear civil cases. Civil cases are simply lawsuits. The civil cases that are heard in the federal system, 99% of the time, are cases that are dealing with some kind of constitutional complaint. You're suing because your free speech rights were not granted by your community. You would sue them in the federal court. So that's what a civil issue is. In regards to how cases make their way through the court system, you should kind of understand how they make their way to the Supreme Court. A court case can go to the Supreme Court all the way through the state system. So it could go through the state original court, it's appellate court, and state Supreme Court, and then appeal to the United States Supreme Court. Most cases go through the federal court system though. And although some could start at the Supreme Court level, most come through the district court. They appeal to the United States Courts of Appeals. After a loss there, they then appeal to the United States Supreme Court. Most of the cases the U.S. Supreme Court hears are those dealing with civil issues. They accept the case through a process known as the Rule of Four. The Rule of Four is when somebody appeals, the judges will look at that appeal in conference, and if 4 of the 9 justices say this is worthy of us putting it on the docket to hear the case makes its on the way onto the court schedule. What they will then do is they will issue what is known as a writ of certiorari. All right, this writ officially calls the case up from a lower court to place it on the docket of the Supreme Court. The Supreme Court, through this process, oftentimes will hear these cases and eventually end up ruling in favor of the precedent that they've already established. This is known as stare decisis, let the decision stand. They'll say a lower court has interpreted our previous rulings properly, we're going to let that decision stand and affirm the ruling of that court. To get your way to the Supreme Court, you go through a basic process in which the first thing you do is you submit your briefs. Your briefs are your written arguments. The justices will review those with their clerks, and then eventually you'll be called in for your oral arguments. Your oral arguments will be heard. You have 30 minutes to make your case in front of the court, and then they will sit and eventually in conference discuss the case and issue the rulings. Those rulings and the opinions are issued through the written word. All right, and so they might issue one of 3 different kinds of opinions. A majority opinion is the official opinion of a court. A concurring opinion is an opinion written by a justice who voted with majority, but he or she has some other perspective on why the individual should have won the case. And some justices write dissenting opinions. Those are opinions that explain why they think the majority got things wrong. Every once in a while, the Supreme Court will make a ruling where they just point out who actually won the case without a written explanation. That's referred to as a per curiam ruling. A final thought on the Supreme Court are the justices and the way they interpret the Constitution themselves. And so I'm just going to throw some vocab words at you that you should understand and kind of connect the dots to. If a federal judge is referred to as a judge who exhibits judicial restraint, that is typically known as a judge who tries to interpret the Constitution in the manner of original intent, the Founding Fathers' original focus on what the Constitution is supposed to mean. Today, it's viewed as more of a conservative manner of interpreting the Constitution. Other justices are referred to as judicial activists. They interpret the Constitution with judicial activism, or what some people refer to as loose constructionists, where they look at the Constitution as a living and breathing document and that it's supposed to grow and be interpreted differently over time, all right, as the world around us change. Those are stereotypically more liberal justices. One other kind of thought on judicial interpretation is recognizing that sometimes when the courts issue their rulings, they focus on what is known as statutory construction, and this helps alleviate future cases to the court. Statutory construction is when in their rulings they'll explain which part of the law exactly is wrong, which part of the statute was constructed improperly, and when they do that, all Congress has to do when they go to rewrite the law is to modify the portion of law that the courts have struck down. And that streamlines the process and can officially kind of help Congress create laws that they know should be above interpretation from the court or have already really been previewed by the court. So that's our chapter 6, and we'll be testing on it on Friday. Thanks, guys.